Charlie daybreak, make we chop small. Delight cocoa.
Delight Cocoa, the authentic, original taste of African porridge. Available in all African and Caribbean shops. Delight Cocoa.
She has a plan, a secret mission filled by gratitude and affection. She chooses her mother's favorite breakfast. Delight Foods, House Cocoa, a harmonious blend of flavors crafted with care and devotion. The taste of tradition and comfort. In that moment, their connection deepens, a bond strengthened by a shared experience. Delight Foods, House of Cocoa, a delicious breakfast made with care and love in just 2 minutes.
Living in Ghana, abroad, a first-timer visiting Ghana, or a company wondering where to get quality service providers in Ghana for any job, then AJuma On-Demand Services is here to assist you. AJuma On-Demand Services connect requesters and service providers such as masons, plumbers, electricians, auto repairers, home and office cleaners, trash collectors, rent agents, spa attendants, roofers, beauticians, teachers, CCTV installers, and all artisans on one platform. Yes, one platform. Trust AJuma On-Demand Services to sort you out any day, anywhere, and at any time. To download the app, please visit the App Store and Play Store or visit our website www.ajumapa.com.
Guys, I welcome you live on SBTV Africa. My name is DJ Nyame. Thank God it's Friday, 5:30. We are a bit late. It's 5:40 now. And today live, if you are watching us on SBTV International, we are also live on our YouTube channel, SBTV International. Live on Facebook, SBTV Africa. YouTube, SBTV Africa. But make sure you subscribe to our new channel, SBTV International. Those watching us on YouTube today, I told you guys that when it comes to English, SBTV International. So we will be going off from SBTV Africa on YouTube. So check our SBTV International page. Subscribe to that channel. Today, I'm here live with Lawyer Wisdom Akao, Wiseman Solicitors. Every Fridays from 5:30 to 7, we are here. And there is a breaking news. Rebecca Brofu. Breaking news with Lawyer Wisdom Akao. Lawyer, welcome you live on SBTV Africa. How are you doing? Wiseman Solicitors.
Thank you very much, DJ. You're welcome too. How are you doing? I'm good. Thank you.
I'm good. Are you back at Studio A or are you still at Studio B?
Studio B will change over to Studio A the next time we talk.
So it's still at Studio B, eh?
Studio B job. So you see that.
Lawyer Wisdom Akao, champion man. So lawyer, I mean, you have we are here today. We are streaming live on 3 platforms, but we'll be going off from SBTV Africa on our YouTube channel.
Okay.
We are streaming live on SBTV International.
Right.
I'll be dropping the link on SBTV International YouTube channel. So make sure you guys subscribe to it, because I told you guys we are bringing more stuff in English so that people in the diaspora and other African countries can also be part of our program. So, lawyer, today what's in the news? Some breaking news, I'm seeing on the screens now.
Yes. Good afternoon, good evening to all our listeners, and maybe good morning, depending on where you are watching us from. Yes, we thank God for another Friday. DJ, yes, breaking news, as you said. Everybody, I believe, who are watching or who is watching can see the Home Office kicks off deportation and, let me add, removal of migrants, skilled workers, and students, and they've been given 60 days usually to make moves. Now, we have all heard, a lot of us, I believe, who follow this channel very closely. I believe we all heard and know of what's going on in the health and care, and also with the student visa section. Now, before I even go on to that, there is this news, there's this case law, and the case is the case of Preswick Care Limited and others Freshwick Care Limited and others, but it's a Secretary of State for the Home Department. That care home have got their sponsorship license revoked. The care home has got its sponsorship license revoked. Now, this is a very big care home that employed 219 skilled workers under the Health and Care Visa Scheme. 219 skilled workers. And when they came, the Home Office also conducted some search on this care home. Now, I'm going to take this and then I will lead to why the deportation or removal of skilled workers and students who have been given 60 days, etc. So now this Presswick Care Home Limited employs, it's a big company, employs it's employed over 219 skilled workers under the health and care visa route. Now, what happened was that the Home Office has a duty to conduct searches and also to conduct compliance visits to these care homes to ensure that they are doing what they are supposed to be doing. Now, unfortunately for this care provider, what happened was when the Home Office conducted their compliance visit in October 2022, it's found that there were a lot of factors leading to revocation, or it consisted of, or it amounted to non-compliance with their sponsorship license. Now, so the Home Office cancelled and revoked their sponsorship license. The case went to court, and the court agreed with the Home Office for cancelling or revoking that sponsorship license of the sponsor. That is the Breadwick and Care Limited and others. Now, what happened was that there were a few things that the Home Office came out with to say these people are not complying with their obligations, their duties. One, what happened was the Home Office found that the care home did not keep good reports. They did not keep good reports about the organization or their sponsored workers. It's a duty that as a sponsor, you must keep a good report about your organization and about your sponsored workers. That is one. Two, they are supposed to keep records on the sponsored workers and their recruitment process of how the company conducts or recruits people to the UK. The sponsor is supposed to keep a report of that, a record of that. Unfortunately, when the Home Office conducted their compliance check, that was in October 2022, the employer was found to be non-compliant, and because of that, their license was revoked in February 2023. The case went to court. Again, another ground on which the Home Office revoked the license of the sponsor of the Presswick Care Limited was they did not comply with the guidance of care homes and the UK law in relation to employment laws. Now, every employer is supposed to pay the employee a minimum income, a minimum level of income in a day, the daily wage, income threshold, the daily minimum income. Now, this company was not complying with that. And also, the Home Office found that there were other things that the care home was not doing. The care home was paying different people different levels of salary, different from what they had stated on their COS. Now, before you can bring somebody to come and work in the UK, you are supposed to issue them with a sponsorship certificate, sponsorship COS, certificate of sponsorship. And on that certificate of sponsorship, you are expected, or the sponsor has to state the amount of salary that the employee or the sponsored person was going to be paid. Unfortunately, they put some figures on that COS, but the employers were not paying the sponsored persons that amount. And on that basis, the Home Office had a good reason to revoke their sponsorship license, sponsorship certificate. The second thing I've mentioned again was non-compliance with the employment law in relation to sick pay. Now, if you have an employee, you are to comply with certain requirements in terms of if the person is not well, sick pay, etc., etc. There was some pay you had to give to the person or the employee. This company, the Home Office, from their records shows that they were not complying with that. They were not paying as they should have been paying. So that was another reason for the Home Office revoking the sponsorship license of this Prestwick care home. And another reason for the revocation of that their license was that the care home was collecting the skills, the immigration skills charge cost from the sponsored workers. Now, before you can apply to the Home Office or to when you apply to the Home Office for a sponsorship license for, let's say, 3 years, there is a fee that you have to pay. Example, 3,000 and 3,199 pounds for 3 years sponsorship certificate. Now, the Home Office observed that the care home, this particular care home, was taking that money from the sponsored workers. That amount of money is not supposed to be taken from the sponsored workers. That was to be the cost of the the care home of the sponsor, not the cost of the sponsored person. However, the Home Office found that this particular care home was taking that money from the sponsored workers, and that was in breach uh, of the guidance that the care worker, the sponsors, had to comply with. And because of that, the Home Office revoked their sponsorship license. Now, the sponsors can take the immigration application fee. They can take the visa application fees from the sponsored persons, but they are not supposed to take the immigration skills charge, which they paid to the Home Office from the sponsored person. They can take the application fee from the sponsored person, but they are not supposed to add the immigration skills charge, which the employer paid to the Home Office. They are not supposed to take that from the sponsored persons. So the Home Office observed that this employer was taking both the immigration application fee from the sponsored person as well as the immigration skills charge from the sponsored persons. So the Home Office said, no, that is a breach of the guidance, and therefore you cannot continue in practice. The other thing the Home Office observed from this compliance check with this company was that there was ineffective monitoring of employees. Ineffective monitoring of employees. That is to say, maybe the record of when they came to work, how long they spent at work, whether they were actually working or went on frolics of their own, doing things of their own selves, claiming that they were working. The Home Office said the employer was not properly monitoring the employees. And on that basis, the Home Office revoked the license of this employer. The other thing was there was a poor record keeping of the records of the employer. Employer was not keeping records of the the employees' records. In other words, again, like I said, the number of days they work, time of reporting, time of leaving, etc., etc. all this were not being kept. And therefore, the Home Office said, no, you are not compliant with the uh, guidance note, etc., etc. And therefore, they revoked the license of this employer. So now this is what happens. So I'm just giving you this as the background to what happens or what has led to the Home Office kicking off with writing to students and skilled workers and giving them some number of days to leave the country. In fact, some of them are not even being given the 60 days at all. Some of them are being asked immediately to leave the UK once their visa is revoked because because they didn't comply with the conditions that they should have when they were issued the leave to be here as a skilled worker or so. So first of all, once your visa expires, once your let me look at it from the employer side first. Now, if the sponsor's business is taken over or they didn't renew their license, what happens is the Home Office, let's say the employer did not renew their license or their business is taken over, the sponsorship license is cancelled following a takeover of an old employer's business. Your new employer does not. Your new employer does not. Uh, Yes, okay. Your employer doesn't renew their license, their sponsor license, following a takeover of an old employer's business. The new employer doesn't apply for a sponsor license within 28 days. It means if, example, the company I just gave, if their license has been taken over or revoked, or another company took over this business, they had 28 days to apply for a new sponsorship license for you for a new sponsorship license for you. Then they can issue the COS and then take over. But if the company did not do that, then it would result in obviously your certificate, your visa being revoked. And once it is revoked, this is what happens. You will be given, if your sponsor's business is taken over or they don't renew their license, you will be limited to 60 days. 60 days. However, if that is if your visa or the leave you have on your visa is less than 60 days, then it is only limited to that period. But if you have a longer period, let's say you have 1 year, it reduces to 60 days. If you have only 30 days, you have 30 days left. If you have only 1 week, you don't say 60 days. No, it is only the 1 week you have. So that is what is happening now. Some care homes are their licenses are being revoked. Some students also who came to the UK and did not attend, the students who came to the UK and did not attend. Some did not attend because of change in circumstances, because maybe when they were coming, an uncle or an auntie or a parent promised that they were going to help pay their tuition fee. Now, upon arrival in the UK, circumstances have changed. And because of that, they were unable to go to school, to go to the university as they should have. Now, once you don't report to the university has a duty to notify the Home Office that this student did not report. Or, apart from not reporting, some students did report, but in other words, after reporting, they took their biometric residence permit, but did not attend as they are supposed to attend. In other words, they went, reported, took their biometric card, but did not continue to attend the course as they should have. Maybe you have classes in 3 times a week, but maybe they attended only once or twice. Now that is not compliant with the certificate or the visa you've been issued. And or some students were also, students are supposed to work for 20 hours a week, but maybe the student was working for more than 20 hours and the Home Office has found out and they've cancelled their leave. Or the license of the school has been revoked. Now, if that is the case, normally you will be given 60 days to leave the UK, or You regularize. In other words, you change your leave into another category. Now, this is what is happening now. This is what is happening now. The Home Office is writing to some students who have not or who did not attend the lectures, who did not report and who did not attend lectures. The Home Office, they've got information from the universities now, and on that basis, the universities have on that basis, I mean, once they inform the Home Office that the student didn't attend, that means that the Home Office has a duty to cancel the sponsorship of the sponsorship of the student or the CAS, and therefore they canceled their visa. You have given 60 days. Some students have not even been given the 60 days. Immediately, the Home Office says you should leave the UK. And they give you a breakdown of what you're supposed to do. If you don't leave the UK, you cannot have a driver license, you cannot operate a bank account, you cannot rent a house, you cannot, of course, access the NHS, etc., etc., etc. 60 days for you to leave the UK. Some are immediate and some are 60 days. That is what is happening now. Now, if you do not leave or you do not change your visa into another category, the Home Office can come to your house. Now, if they know where you work, they can come there and then cause arrest. They can arrest you, they can detain you, take you to detention center, and from the detention center, you are removed to your home country. That is what is happening. That is the breaking news we are talking about, that the Home Office is now writing and writing and writing to students and the student dependents, students and their dependents who have also become overstayers because the student did not attend the school or didn't go to the university. Once they cancel the student's leave or visa, the student dependence visa is also affected. This is what I say: the tree moves or falls with the branches. Now, if the tree falls, it falls with the branches. If the tree is uprooted and moved, it moves with the branches. So if the student is falling because they did not attend and their visa has been cancelled, the same cancellation applies to the student dependents. Either the wife, the husband, the children are all affected by the revocation of that visa. So this is what is going on. Removals of students and skilled workers who have been given 60 days. Now, if you have any letter as such and you've been given 60 days to either regularize your leave or leave the UK, seek legal advice. Seek legal advice and as to what you should do. What can you do? There are options. Now, if you I've mentioned this some time ago, but I'm not going to go over. So I'm not going to go over it into too much detail. It is possible to switch to the family route. Maybe when you were here as a student, you have formed a relationship, and maybe you have a child. You can switch to that child. You become a parent in the UK. You can switch from being a student whose leave has been cancelled to becoming a parent if you have a child in the UK. That application can be made under Appendix FM, section Leave to Remain as a Parent. If you have a child and your child is a British citizen, or your child is 7 years in this country, maybe the child was here, the child and the mother were here before you came to join them, and you have contact with your child, you can switch from the student visa that has been cancelled or revoked and you become a parent. You don't have to leave the UK to do that application. Or if you form a relationship, genuine relationship, and your partner has a child, and it's not your child, but it's your stepchild, and there is a genuine relationship between you and your stepchild, then of course you can apply based on your stepchild and your partner again, to stay in the UK. You don't have to leave the UK to make that application. Again, that application can be made under paragraph appendix FM section LTRPT. As the first one is PT as a parent, and the second one is as P as a partner, based on the fact that you have a partner and you have a stepchild. So that is an option for you. Now, within that 60 days, if it is also possible to get a sponsorship certificate, another sponsorship certificate, because within that 60 days, you are deemed to be in the UK legally, lawfully. So within that 60 days period, you are able to switch from one category to another category. If you can get another sponsor within the 60 days, then of course you can get a new sponsorship certificate and certificate, and then you switch to another sponsor. That is a possibility. You can switch to that category. Or if you were already in a relationship and you were not married, but within that 60 days you marry, whether there is a child or no child, as long as you are genuinely and legally in the UK, you are able to apply for your leave to remain in the UK during the period of your 60 days. That is a genuine period of, that's a legal period of being here in the UK. So these are some of the things you can do legally by using the law to remain in the UK within the 60 days. Now, if you wait and the 60 days expires and you don't do anything, then you become an overstayer. An overstayer. There are some applications you can still submit if you are an overstayer, but there are other applications you cannot submit if you are an overstayer. If you overstay the 60 days and you still have a child that is a British citizen, or your child is 7 years old, again, you can apply based on your child to be in the UK. Or even if you overstay and you have a step child, you marry and your spouse has a child, again, same as you did within, or you could have done within the 60 days, you can still apply after the 60 days, even after your visa, the 60-day grace period expires. You can still apply for your leave to be here. In the under the family route, you can. However, if the 60 days expires and there is no child involved, you don't have your own biological child and there is no stepchild involved, and you are in a relationship, then you have to go out of the UK, stay out for, let's say, 1 year. That is if you overstay for more than 30 days after the 60 days. You have to stay out of the UK for 1 year. And then you can then make an application under Appendix FM section EC-P. Then you are able to come back, but you should meet the other requirements such as the financial requirement, relationship requirement, English language requirement, accommodation, and etc. etc. Tuberculosis you should have done, and all the other requirements should be satisfied. Now, once you can prove this, then certainly you are able to apply to come back to the UK. So, generally, yes, it is true that some care homes are having issues and their licenses or their license being revoked or cancelled or suspended. That is one. It is also true that some students have got their leave cancelled, and it is also true that some care workers are not able to find work and working with their sponsors, or their sponsors' license has been suspended and they've been given 60 days. Well, all these things are truth, they are facts. Yeah? But it also means that you have a grace period of 60 days. If you've been given that grace period of 60 days, you are able to move to another category. If you do not have the grace period at all, or your leave is cancelled and you have to leave the UK immediately, again, you may be able to use the law and switch to the family route, as I have already discussed, to change from whichever route you are on now to another route. That is also a possibility. So yes, I would say, all in all, if this happens or you happen to find yourself in a situation of this nature, please seek legal advice and you'll be able to either switch, or if you want to go back home, you can then go back home. Just before I started this program, I had a call about somebody who came as a sponsored person, as a care worker, and with the dependent. Unfortunately, because the main applicant wasn't getting work with the sponsor, they decided to go back home. Now the dependent is still in the UK. So the question is, what should a dependent do? Well, in a situation like this, I would advise you to quickly seek legal advice. If you want to call us, you can call us. And of course, you come, you sit down with us, we discuss what the law says, your right or your options are. Then you can decide what to do. But of course, if you don't want to stay in the country, you can just pack your bag and baggage and buy your ticket, and then you leave the UK. If you need help with going back, the Home Office may help you, but that only means that you'll be out for a very, very long time. But if you go yourself voluntarily, you are able to come back in another category. So, DJ, generally, this is what is happening. Yes, letters are being written to students, letters are being written to care workers, letters are being written to people that their leave is being cancelled because either the care home has been revoked, the care home license has been revoked, they didn't go to the school, the sponsors, some of them have even got divorced. They came together, there's a divorce, the man is going their way, the woman is going separately, the one party doesn't have a right to be in the UK and they don't know what to do. The Home Office is just churning out letters to lots of people. Leave the country immediately or leave the country within 60 days. If you do not want to leave, seek legal advice. Seek legal advice as to what to do. This platform cannot exhaust the options you have or the details of the options you have. But if you seek legal advice, you sit down with a solicitor, they are able to tell you this is the law you have, this is the option you have, and then you advise yourself as to whether you want to stay or not. If not, you can pack your bag and then you go back to your home country. So, DJ, it is true that the Home Office is giving letters to people to leave the UK.
Wahala don't dey. Wahala don't come. Wahala don't come. Anyway, we are live on our new YouTube channel, SVTV International. So make sure you subscribe to SVTV International so that you get notification. Like we said last week, today we'll be doing English. Next week we'll do our local dialect, which is Twi. And then the following week we'll do English. So make sure you tap on subscribe so that you get notification on these two channels. Our SBTV Africa, if you're already subscribed there, make sure you subscribe to the new channel too as well. If you have not subscribed to SBTV Africa and you have subscribed to SBTV Africa, SBTV International, sorry, make sure you subscribe to both channels. So you join us there, you drop your comments. Share the links to your friends and your family, your loved ones to join us. You can drop your questions at the comment section and I'll put it on the screen so the lawyer will answer when the time is up. That is 6:30. I'll drop your questions. I know we are streaming live on our new channel, so the views are not there much because they are yet to know the channel and all that. But on Facebook, I can see the numbers are there, which is SVTV Africa. We have the link of SVTV International on the caption, so make sure you tap on it and subscribe to our YouTube channel because we'll be bringing more interviews after lawyer. We'll be launching more interviews, new ones with people from the diaspora and other African countries and all that. So, lawyer, that's it. That's the news for today.
Yes,
So
that's what is actually going on, and it's DJ. It's serious. If you know the number of people who call me every day with letters of revocation of their visas, like I said just before I came on the program, I had calls because the woman is not getting work, so she is going back to Ghana. The question is, what should the dependent do? Now, once the Home Office gets to know, the Home Office will cancel the dependent's visa. What is it going to
my
do?
lawyer, it's a big blow.
It is.
the number of skilled workers and these students too
Yes.
is crazy.
You know, somebody told me something the other day, who happens to be a recruiter. She happens to be a recruiter. Now, this is what she said, that they have this same program for other countries. The NHS has different programs for other countries, from Zimbabwe, from Sierra Leone, from other, and they do it in such a way that when they come, they train them, give them job, monitor them for some time. But Ghana, when they came to Ghana, Ghana said they needed their nurses, and therefore there was a lot of restrictions as to what they can do for these people. Because the other countries, when they come after 2 years, in fact, they'll train you, take you through the process. In fact, they are not training you as a nurse. You're already a nurse. When you come, they have to just do some adaptation and they know how to use their system. After that, you are bonded for, I think, 2 years. After 2 years, you can move on to any other place. Those countries did not say that they needed their nurses, but Ghana said they needed their nurses, and therefore it becomes restrictive for them to employ these people. And that is part of the problem we have. And because they are not able to do it legitimately through the NHS, that is where you get these fake and sham sponsors taking advantage of people, bringing them, getting them stranded, no work for them, no place to stay, undercutting their pay, not monitoring them, subjecting them to torture more or less. Some people just travel. Somebody told me he's traveled for 1 hour to do a work for 30 minutes. And then he has to go to another place, travel another 1 hour to do a work for 30 minutes. You are not paid for the travel time, you are only paid for the 30 minutes work you do. So because they are not able to recruit through the NHS genuinely, that is why we have these fake and sham employers and sponsors and all people bringing people and taking advantage of them. Until, especially in Ghana, we are able to do it and do it well. It's unfortunate that this problem will be arising and people will be taking
Unfortunately,
advantage.
we are
Very
always causing mess. When there is opportunity, we will dig the place and then we cause mess.
Yes, and this was told me by a recruiter, someone who recruits people. He says, yes, Ghana, that's the problem we have. The other countries, they don't have problems. They are paid well, they are taken care of well. But Ghana, we have the problem of saying we need our nurses, and because of that, they are not able to recruit.
All right. So if you just join us, we are live on SVTV International YouTube channel. Make sure you join us there. The link is on the caption. You can just click on it and just tap on subscribe so that next time you will not miss it. We are also live on Facebook, SVTV Africa. Today we are not streaming on YouTube, SVTV Africa, but we are streaming on our new channel, SVTV International. So, Lawyer, let's continue. You can drop your questions. If you have any questions to ask Lawyer, you can drop it. But before that, I think, Lawyer, I have some questions for you. I want you to tackle those questions first. Then I'll come to the comment section. Then we can take it from there. All
All
right.
right, sir. Okay, sir. Thank you.
So let me put this ones. Let me drop this ones. Then we can just start. Okay. So let's take it from this one after the other.
Okay, thank you. As I am applying for a divorce based on separation, but I do not know my wife's address. Can you suggest any ways for me to trace her? Well, yes. Now, divorce is at the point where the parties cannot proceed again as husband and wife. Now, under normal circumstances, you should be able to trace the other party because you cannot divorce somebody if they don't know, they are not given notice or any information that your other part, the partner is filing for a divorce. Now, so what happens then is there was the change in the UK law recently. Before the change, you have to prove there's a ground for divorce. There's only one ground for a divorce. There was only one ground for divorce and that one ground has to be supported by one of the five factors. The ground for divorce is that the marriage has broken down irretrievably and the parties cannot be expected to live together again as husband and wife. And there's supposed to be one ground, one factor to support it, either 5 year separation, 2 year separation with consent, unreasonable behavior, adultery, or desertion. However, the UK has now taken away all those requirements. You don't have to prove anything. There is now no fault divorce. You don't have to give any reason why you don't want to carry on with the divorce. If you don't want to carry on the divorce, just file your divorce and say you don't want to go on with the divorce. As simple as that. You have to serve the other party, or the other party has been notified. You need the marriage certificate. I believe you have it already. Now, if you don't know her address, the court has a system that they may be able to trace it. Or there is something we call, there's an organization called Process Service. Process Service. They are able to trace and look for the person for you. So you can use the Process Service as a way of searching for the address of your wife. Of course, they will charge you a fee for that service anyway. The other thing is you could go online, you use Facebook, you use Twitter, you use all these social media handles. You can use all of that to track or to trace the person. Now, if you can't, or if you do all of that and you still can't find the person, you have to print the evidence of all that you have, all the searches you've done, to prove to the court that you've done all the searches and you can't get the person. Of course, you can also probably write to maybe the local area in which you lived. If you lived in, let's say, Edmonton, you can write to the Edmonton Council, maybe the GPs in the area, maybe where you once had your GP as a couple. Now you can write to that GP if the person has still, if they have your wife's details there, they can serve her on your behalf, or they should pass it on to her. Or if they don't know, they will return the letter to you. The council can also be written to. If they don't have a record, they'll return that letter to you. So this, in addition to all the social media searches you conduct, Facebook, Twitter, X, it's not X, Facebook, X, WhatsApp, and all those other platforms you search for the person. If you can't find them, print the evidence that you have searched. Use all of that as a way of proving to the court that you have done your searches. But normally you will need the person's, these days you need the email, the telephone number, and the address. Is the address, if you don't know, you can provide the email and the telephone number if you have it. Thank you. There's another question says, I came here with 2.5 years visa with my wife. After 2.5 years, my wife completed the form and we applied, and I was given another 2.5 years. I have been here for 5 years now. I went to a lawyer to apply for indefinite leave, but he said I cannot apply for indefinite leave because I was put on the 10-year route because I applied and I did not add the English test. He said I have to do 5 more years. Please, can you explain or help? Yes, can you help me get my indefinite leave to remain? Yes. Yes. Now, this is quite technical. So I agree with what the lawyer said based on the information you have given me. Now, if you apply for indefinite leave to remain, there are some conditions you should meet. Now, you said you came to the UK with your wife with 2.5 years limited leave to remain. You are supposed to do 5 years continuous residence to be in the UK. So, when you applied for the second 2.5 years, you were supposed to have met some conditions. 1, relationship requirement. It means you are still living together or you are still together as husband and wife. Even if it is not necessarily under the same roof, you still have to prove that the marriage is still subsistent and it is genuine. That is 1. Number 2, Immigration status requirement. You are supposed to show that you have a valid visa. Your visa should not have expired before you applied. And so if your visa didn't expire, you apply once it was still valid, then you met that condition as well. The third one is financial requirements. That is F. Financial, that is, it has you have to show that you met the £18,600 requirement at the time you made a second application for at the time you made the application for your second 2.5 years. So I believe you met that as well. But it appears from your message, the message that you did not meet one of the requirements, which is the English language requirement level A2, unless you had a first degree that or certified by ACTIS. Now, you did not indicate that you met or you produced the English language certificate. Now, if you did not add or provide English language certificate level A2, you were very fortunate that the Home Office gave you another 2.5 years. 2.5 years. But the second 2.5 years they gave you was not under the 5-year route, it was on the 10-year route. 10-year route because you did not meet all the requirements for the 5 years route. The 5-year route, again, I said relationship, immigration, financial, English language. Because you did not meet the English language, they took you off from the 5 years and placed you on the 10-year route. So when you went for your indefinite leave, remember you are no longer on the 5 years, you've been put on the 10 years. So you cannot get indefinite based on your 2.5, 2.5. You were put on the 5-year, on the 10-year. So the lawyer was 100% correct by saying you have to do another 2.5 years again, and on top of the 2.5 years you had done the second time, then that may bring you back to the 5-year round. So you had to make an application again for another 2.5 years, which you had done in addition to the ones you had already done. Possibly you have to end up doing 7.5 years before you get your indefinite. Unfortunately, this happens, but that is what happens if people try to apply for themselves without seeking legal advice, because the law is very specific when it comes to some of these requirements. If you don't meet it, unfortunately, your visa will be refused and there's nothing anybody can do about it. But thankfully, you've been put on the 10-year road, so you just have to apply again. My wife's appeal was successful, but I received an email that they cannot give her the visa because they found that some information she gave with the application was not correct. What can we do for what can we do for her to come? Well, the Home Office or the Secretary of State has a duty that even if you made an application at the time and it was refused, and you went to court and you won the appeal. Now, between the time you won the appeal and the period of implementation, if the Home Office goes back and finds out that some information you provided at the time of the original application was false, they can still refuse to issue you the visa. So that is exactly what your wife finds herself in. If maybe she used some false document, some false, or she gave some false information, maybe she used a different name, but she never disclosed in the application in the appeal that she used a different name. Or maybe she changed a date of birth because she found the correct one later and didn't disclose that this was my previous situation and now I've changed it. And the Home Office goes to find that those informations were withheld or those informations were not provided. And if they had known at the time, it would have affected your application. They can again say they would not issue you the visa because you did not disclose those information. So, what do you do? I would like to see this decision. See the decision, I know exactly what is said in that decision, then we can advise. If not, then you may have to make a fresh application and then disclose all the necessary information in the new application. Thank you. So I have 2.5 years leave, which would expire next year. Unfortunately, my husband died from cancer 6 months ago. Sorry to hear that. Please, can I still make application to stay, even though my husband is died, is passed? Yes, my condolences to you. You can still apply to stay in the UK, and this time you can go for indefinite leave to remain straight away. You don't have to go for another 2.5 years, but you can go straight for indefinite leave to remain as a partner of a bereaved person. This application is called indefinite leave to remain as a partner of a bereaved person. So, yes, this application you can make it, and you need some documents to support that application. The first document you need is the death certificate of your spouse. You need the death certificate. Now, it will be very helpful if your name was on that death certificate as the informant or the spouse. That would be very, very helpful for you. The next thing you need is you need to prove that you were actually living together as husband and wife before your partner passed away. So, what do you have to prove? You need proof of address, gas, water, electricity, telephone bills, and other things that shows that you were actually living together as husband and wife before your partner passed away. Now, of course, you can also provide pictures of the funeral ceremony, uh, pictures of when he was laid in state, the cemetery, the undertakers, the church, etc., etc. All these pictures you can provide to prove that yes, this was a genuine relationship until my partner passed away. Now, with these documents, you are able to apply. It has to be done and done very, very well. Otherwise, you may not get your indefinite leave to remain. You may be given another 2.5 years if you don't prove very well. Uh, this application can be done, but it has to be done well. Thank you. It says, my sister's application was refused. How many days do I have to appeal? The date on the letter is 14th December. Well, if an application is refused, you have 28 days to appeal. If it is from outside the UK, you have 28 days to appeal. Today is the 12th of January. I think today should be the 28th day. That is, if you got the decision on the 14th. Otherwise, if you got the decision, even though the decision was dated 14th December, but maybe you got a decision on the 20th or 22nd or 23rd, then the 28 days starts counting from the date you received the decision, not the date on the letter. The 28 days starts counting from the date you received the decision, not the date you received, not the date on the letter. There is one I am dealing with now. Even though the decision was made, I think on the 4th or so of December, they never received it until just a few days ago when they called the Home Office and they said they had sent a decision and they never received it. So the Home Office had to resend it. So the resending puts the decision on the 28 days starts from the date they resend the decision to the person, not the 4th or the 2nd of December which is on the decision. Thank you. So I came to the UK with a different name, but I now use a different name. I have two children here, and they have my new name on their birth certificates. Would that have any effect on my application to stay as a father of British children? No, that should not affect you as a father of British children, should not affect your application. Now, on every application form, when you completing the form, they ask you some questions. One, your name, date of birth, etc., etc. And the name section, they ask if you have been known by any other name, if you've used another name before. Now, if you have used another name before, you just have to tick yes, and you provide the name that you used before. And they will then ask whether you enter the UK with that name. If that is the name you came to the UK with, you just enter that yes. If that is not the name you came to the UK with, you just also have to say that that is not the name you came with. And then they would ask you if you change your name officially. If you did a deed poll or change of name deed, you have to tick yes. And if it is officially changed, then they ask you for the date it was changed. If it wasn't changed officially, you tick no. And then they ask you other. Now, in what status or in what capacity did you use that name? Maybe use it as an alias, just as another name. So you take that and you move on. So this should not affect your leave to remain in the UK as a parent of British citizens. My main concern for you rather would be to meet the other requirements, such as genuineness of the relationship between you and the children, whether you have a letter from the school or letter from the hospital or GP, whether there is the child's or the children's mother will give you a letter, and all those other things, the children's passport copies, the proof that you are being supported by somebody, etc., etc. If you can meet all those requirements, then I can say your application stands a very good chance of being successful. Thank you. I have indefinite leave to remain under EU law. What would I need to apply for my husband to come, and will I need the 186 or the new income? Will the new income be needed? Or the new income be needed? Okay, right. The new income is not taking effect until spring 2024, and we believe it's going to be in March 2024. That is when the new income threshold of £29,000 will take effect. Now, in which case it means that until then, it's £18,600 that is still the financial threshold that you need to prove to support your application. So 18,600 is what you need. You need to show again genuineness of the relationship, communication, WhatsApp messages, money transfer, visits, etc., etc., pictures, and everything. That is that side. You need to show the 18,600 is met. You need to show accommodation is requirement is satisfied. You need to also show the English language requirements, and all these are satisfied. Once you can prove this, then you can go ahead and submit your application for your partner to join you here in the UK. Thank you. I will be 20 years in the UK this March, in March this year. Can I make the application 28 days before the time? Unfortunately, you cannot submit your application 28 days before the time. You can't. You would have to wait until you are 20 years in March before you can apply. So if it is the 1st of March, submit your application from the 2nd of March. If it is on the 3rd of March, submit your application on the 4th of March. In other words, submit your application one day after you are 20 years in the UK. Don't send it one day before. sign it one day after, so that the Home Office doesn't use its discretion to say that you applied before you became 20 years settled in the residence in the UK. So please don't submit before the 20 years, so that the Home Office, they do not come back and say you didn't apply when you were 20 years. So please take note of, of that. Um, and of course, you need a lot of documents to show that you've been here for 20 years. I was given 2 years visit visa, but I stayed for 1 year. Can I make application based on a stepchildren? On stepchildren? Yes, of course. I think I just mentioned this sometime back a short while ago. You can make application based on your stepchildren if they are British or they are 7 years old, at least 7 years old in the UK. You can make your application. Yes, you can make application for your children based on your stepchildren if you've been here for you've been here for 1 year, even on a visit visa. But you have to prove that you are married to the stepchild's mother, or the law is changing from the 31st of January this year, which says that you don't have to be together for 2 years before you can prove there's a genuineness of relationship. But as long as you can prove that there is a genuine relationship during the period you are relying on, it can be 6 months, 8 months, 10 months. As long as you can prove that, that is good enough. You don't have to be together for 2 years. And you don't necessarily have to be living under the same roof, because people are in a relationship, but they don't necessarily live together. As long as you can prove it, that is fine. What can I do for my children to come here? They are 13 and 15 years old. I have applied for my second, my 2.5, but I'm waiting for the Home Office to reply. Well, if you have applied, if this is your first 2.5 you have applied for, I would advise you to wait until you have your decision before you apply for your children to come and join you. Thankfully, they are under 18 years old. They are under 18, so just wait for your 2.5 years to come before you apply for your children to join you here in the UK. Let me say it in a different way. Do not apply for the children until you have got your 2.5 years limited leave to remain. Then you can apply for them to come. Now, if you got your 2.5 years, or if you get your 2.5 years based on being a parent or a partner, then you can apply for your children to join you. But if you get it based on human rights, then that limits you. You can't apply. But even if you do, then it has to be under Article 8, which is very difficult to win. So just bear that in mind. However, if you had your 2.5 years and you're going for your second 2.5 years, you don't have to then wait for your decision to come before you apply for the children, because you already have 2.5 years. You are not going for another 2.5 years. Once the application is still at the Home Office, you are still here legally, and therefore you can apply for your children to join you whilst your application is pending at the Home Office. In any case, you can still wait until the decision comes before you apply. Whichever you're more comfortable with, you can. But remember, you have to meet some requirements. If your partner is not the mother to the children, then you have to meet something we call sole responsibility. But if your partner is also the mother of the children, then you don't have too much of difficulties to meet. But if not, then sole responsibility comes, and sole responsibility is very tricky. So you have to again seek a more detailed legal advice before you proceed with that application. The next question is: I have a partner and I have lived together for. I have a partner and we've lived together for more than 1 year, and we are expecting a baby. Can I make application once the baby is born? Should we apply for passport for the baby before I apply for my visa? Well, yes, you can. It's two questions. Can I apply after the baby is born? Yes. Do I have to apply? Do I apply for British passport for the child before the baby? Before I apply for mine? No. Now, the reason why you can apply as soon as the baby is born is this: if your partner is a British citizen, or your partner has indefinite leave to remain, once the child is born under Section 1 of the British Nationality Act 1981, I'm sorry, under Section 1 of the British Nationality Act of 1981, the child is automatically a British citizen. The child does not need a British passport to be British. They're already British. So as long as you can prove that the child is British because the mother is settled or the mother is British, that is grounds enough for you to proceed with your application once the baby is born. However, if you also want to apply for the British passport for the child before you go ahead to apply for your leave to be here, that is also perfectly allowed. Now, I was given a visa based on my relationship, not marriage, and we have a child who is now 10 years and he has no British passport. I have problems, so we have problems, so we don't live together anymore. Can I still apply based on my ex-partner? If not, can I use my child who is 10 years to apply? Well, thank you. You can't apply based on your ex-partner because you are no longer together. Now, if you are no longer together, then it means that you do not meet the genuine and subsistent relationship. You may meet the genuine relationship at the time it was there, but you don't meet the subsystem, which is it's not continuing. If it is not continuing, then you can't base it on your partner anymore. But you can switch to your child that is 10 years old. I believe the child was born here and has lived here for 10 years. You can apply for British passport for the child under Section 1(4) of the British Nationality Act 81, and the child get a British passport. Or you can still apply for the child and yourself, but there's no point in applying for the child. It's going to be a waste of money. If the child was born in the UK and is going to be eligible for British passport citizenship anyway, there's no need to apply for the child and yourself. But you can apply for yourself based on your child who is 10 years or who has been in the UK for 10 years, living in the UK for 10 years. You will need to make that application under Appendix FM, Section LTRPT of the immigration rules. You will be given 2.5 years limited leave to remain in the UK. I was given 2.5 years visa, but my child is now more than 18 years old. Will it affect my application? No, it should not affect your application. Once you can still show that there is a genuine relationship between you, your child, and the child is dependent on you. But if the child has gone on to form an independent life, they've moved out of the house, they are living by themselves, they are married, or they have their own girlfriend, they have nothing to do with you, they've cut off totally with you, you don't put money in their account, there is nothing showing there's correlation, there's a relationship between you and the child, then that can affect you. However, even though they've turned 18 and they're still living with you, maybe they go to uni, but they still come back home, and you can prove that you are still responsible for them. Yes, 18 is an adult, but still you are responsible for the child, and therefore your visa or your leave will not, NOT, be affected as long as you can prove that the child is still dependent on you. Again, if they've moved on to live, form an independent life, and they don't have anything to do with you, then that can affect your application. DJ, thank you. If I make my application before my child became 18 years old, will it be okay? Yes, of course. If you made the application before your child became 18 years old, that is fine. I mean, as long as they're under 18, you can apply either for, if it's your child or your stepchild, you can still apply based on your child or your stepchild that is under 18 years old. But they should meet the other requirements. Either they've been in the UK for 7 years, or they have indefinite leave, or British citizen, you can apply. If you're applying for them to come from outside the UK, then of course you have to submit the application before they turn 18. Because once they turn 18, they are no longer a child, they are adults. They become an adult. So you can't then bring them, or it becomes almost impossible for you to bring them if they are gone past 18 years. Next question. I have 2.5 years visa. Can I apply for benefit? I am really suffering and I'm depressed. Sorry to hear that. Sorry to hear that. Yes, circumstances do change. Life happens. Difficult times arise, and it happens. But there's always a way. There's always a solution. You cannot apply for the benefit if you don't remove the no recourse to public funds from your biometric permit. So what you need to do is apply for the no recourse to be removed, change of condition. And once they take it off your card, then they'll issue you a new card that will have no condition attached to it. On that basis, you are able to apply for benefits and you should be uh, supported. So I came to the UK. Next question. I came to the UK with my son when he was 3 years old. He's now 16 years. Can I make application for the two of us? Yes, you can make application for the two of you. So it means the child has been in the UK for 13 years. The child was 3 years and is now 16. That is 13 years in the UK. You can apply for yourself and you apply for the child. The child's application will be made under Appendix PL and yours will be made under Appendix FM. So yes, you need evidence to prove all of this, and you will then be able to submit your application for yourself and your child. Now, if you do not have money, genuinely, then you can apply for fee waiver. Fee waiver can be applied for, and that once you're given the fee waiver, you will then be able to move on to make the application for yourself and your child. Thank you. Do I have to do a DNA to prove a child is mine before I can apply? Can apply on her? No, you do not have to do a DNA. It's not compulsory. DNA is not compulsory. It's not mandatory, but sometimes it helps your case. It helps your case because what happens is if the birth certificate was recently issued, if the birth certificate was recently issued, then the Home Office would expect to see some additional proof which shows that the child is your child truly and not somebody's child you put your name on. So in that case, that is where they may want you to provide a DNA. It is not compulsory, but you can do it to help your own case. Yes? All right. And the next question is a friend said I can get or can set ILR based on domestic abuse. Is that true? What do I need to do? What do I need to do so? I can, I'm sure it's set indefinitely LR. I can set ILR based on domestic abuse. Well, if I understand it means I can, of course, apply for indefinite leave to remain based on domestic abuse. Yes, you can apply for indefinite leave to remain based on domestic abuse. Now, what happens is you need to prove that there is a genuine or there is truly a domestic abuse. And what it means is you need evidence, maybe GP's evidence, you need medical evidence, police report, and maybe independent social supporters who can give you report to say yes, you are actually a victim of domestic abuse, and then they'll be able to use that for the application. Yes, so you can. Hello, Mr. Stephen Udum. If the sponsor failed to comply with the rule to protect the employee, that's migrant exploitation. There should be some protection for the migrants, but not visa revoke. So unfair. Well, yes, I can really understand your point. That is very, very I think very fair. Your argument is very fair, but it's because of the sponsor. That is why the employee is in the UK. So once the sponsor's license is revoked, or the sponsor has failed to comply with the conditions, and their license is revoked, unfortunately, it affects the employee. That is why the Home Office gives the 3 months or the 60 days for the employee to try to shift from one section to another. It's not like they tell you we've cancelled or we revoke the visa today. We revoke the license today. Pack your bag tomorrow and leave the country. So at least it is not fair, but they have given 60 days, some period that you try to look for options to switch on before the 60 days is over. And that is why you can switch to another company as well. And I'm sure that at least you get some options. But I've always advised people to contact the NHS. The NHS, if the NHS can sponsor them with new sponsorship as a license. Yeah.
Okay, lawyer, before we go to, I think this question is direct to me, so let me just answer the person. The person is asking of my contact. My numbers are always on the screen. So when you go on Facebook, even on our YouTube channels, my numbers are there, both SVTV International, SVTV Africa. So just send me a WhatsApp message, but don't call me. I beg. Just send me a WhatsApp message or voice note. I'll respond. Thank you, Nana. Nana, you're gentle. I have answered you. So, lawyer, let's continue. We are live on YouTube, SVTV International today. We are live on YouTube, SVTV International. So make sure you subscribe to our channel so that next time you will not miss it. And also, we are live on Facebook, SVTV Africa. It's the same company, but different programs. When you talk about SVTV International, it's English. That's one. That's why today I'm speaking English with lawyer, but normally, I do P. So our interviews, our English interviews are on SVTV International for people in the diaspora and the Africans and all that. So you just go on our channel. We have a lot of videos there that you can watch. It's in English. And SVTV Africa, that one there. Died Ghana for Jaffa. So, lawyer, today I think your network is a bit slow. I checked my speed here and then I'm okay. I'm fine, but your place is breaking small. Let's take this one. Let's go back to the questions.
Okay, thank you. It says, what about if you're an EEA? How do you bring a younger friend to the UK? That is Ernest Kwejo Ansa. Hello, Mr. Ansa. Now, if you're an EU national and you are in the UK with the settled or the pre-settled status, unfortunately, when the UK left the EU, they cut off all extended family members. Friends have never been part of the family relationship, but extended family members, maybe brothers, sisters, nephews, nieces, uncle, auntie, all those categories were part of the extended family relations. But from the 31st of December 2020, when the UK left the EU, all those categories have been cut off. So there is no way an EU national in the UK can now bring an extended family member. If they are family members, that is fine. Family is wife, husband, children, grandchildren, father, mother, grandparents. That is direct family. You can still bring them, but not friends or extended family members. And so, Ernestina, hi, my student dependent application has been refused, and now my biological child for my ex-husband, whose father is British citizen, British, has received his British passport. Can I apply visa using my child's document? Sister Ernestina, 100%. You can then switch to your child passport as a British citizen. You cannot switch to your child's leave on the parent basis as a parent of a British citizen child. Yes, you can 100% switch to apply as a parent of a British citizen child, a child that is a British citizen. What I don't know is if you are already in the UK or you are coming from outside the UK. If you are in the UK, that is pretty straightforward. If you're not coming from outside the UK, that is also possible, but the requirements are quite a lot. You need to show financial, you need the financial requirements. You have contact with the child, you have a job to come and do, you have to pass the English language requirement. Those are there. That is if you are coming or you are now applying to come to the UK. However, if you're already in the UK, straightforward, you can apply based on your child. Hi, Linda. What about a student who has finished his course but is working? Well, if you're a student and you finish your course, you can, of course, apply for the graduate route. Apply for the graduate route. The 2 years, they give you 2 years, and you should be able to work within that 2 years. And of course, if you want to stay on longer than that, then of course you seek advice during that 2 year period and see which options would apply to you. Your lawyer, or if you come and see us, we will give you all the options. This, that, or that. Don't do this, don't do that, or do this, or do that. Based on what the law provides, then you make a decision before you proceed from that basis. Hello, Nana Randy. I am live on SVTV International. Thank you for coming on. Thank you. We are grateful. Amina Karibu. Hi, Sister Amina. Good evening. Please, what happens to a single mother without document who has given birth and was given hospital bill to pay within 30 days? If not, will be taken to court by the person is staying with. Or the person is staying with. I think there's an addition to come. All right, let me just address this question. Now, if you have no papers, you don't have the right to be in the UK, and you have been given invoice because you have given birth and you've been given an invoice to pay within 30 days. Now, obviously, if you are not working and you can't afford the whole amount within the period they are asking for, please contact the NHS, contact the hospital where you give birth, and come to an agreement with them. Terms of payment. Come to an agreement with them. If you can only afford £100 a month, let them know. Come to some agreement with them. They will give you a payment plan, and then you'll be paying that. If you can afford £200 a month, yes, that is what you'll be paying. If you can afford £50 a month, agree with them. If it is £10 a month you can afford, agree with them. Agree with them, and once you are complying with the payment plan as agreed with the NHS or with the hospital, you don't have any problem at all. But if you do not have any payment plan with them, you don't agree anything with them, if you apply for leave to remain, that can be used against you. Your leave can be refused. Your application can be refused if you owe the NHS for more than £500 and you've been given an invoice and you do not pay or you don't have any agreement with them. Your application will be refused under the suitability requirements. So please speak to them, have an agreement with them, and you should be fine. Oh, really? Okay. Okay.